welcome to my YouTube channel. I'm Anna Fernandez. I'm an attorney at Legal Lotus in Miami, Florida. And in this video, we are going to briefly talk about what happens when there's a husband and a wife, or a husband and a husband, wife. There's a party that's married, they're filing for divorce, and only one of the parties is included in a title to a property. So we've talked about this before, and of course I'll include links to previous videos that have to do with marital assets, especially the home, because it's a big one. Most people, if you're married, the biggest asset that you may have it's typically the marital home. So what happens if one of the parties is on the title but the other spouse is not? Most people believe that I guess it would be considered non-marital if, why didn't they add the spouse to the property? For whatever reason it may be, the first step you always look at the title, see what it says. If it includes both, that's pretty standard, pretty self-explanatory. But it becomes a little more complicated when, let's say, for example, there's two spouses, they're gonna file for divorce. There's only one person in the deed. And they're claiming, well, it's not a marital asset because I never included my spouse. Well, there's several ways of going about it. If you want to have that argument or claim that the spouse that's not on the title is in fact has some sort of equity, or should be entitled to half, or should have some sort of equity in the home. First thing you look at is, where were the mortgage payments being made from? Was it made from a joint account? Was it made from an account that only listed the spouse that was not part of on the title? These are things that will give the party that's not on the title, it will give you an argument to say, well, it is marital asset because it was paid through marital funds, it was paid through me, I contributed to the increase of the value of the home. I bought hurricane-proof windows, especially in Miami, Florida. They're pretty expensive, but at the end of the day, anything that adds value to the property that you contributed to, you will most likely have a claim for some sort of equity in the home. I'm not saying it's going to be 50-50, but it's definitely an argument that you have. There are sometimes provisions in prenups that may prohibit this, but if you don't have a prenup, then it's pretty standard that you will have a claim in equity in the home for at least a value of whatever increase you may have contributed to the property. So then there's another thing that I do want to mention. It's happened before where, let's say, the parties, they're claiming homestead. If you're claiming homestead to the property, that gives some sort of, not necessarily a right, but we won't get too into homestead, but I just want to bring this up in the sense that, let's say you're about to file for divorce and you're the only one on the title. Your spouse is not. You want to transfer that title to avoid any type of claim that your spouse may later come and say, well, I contributed, or it was paid through a marital account, and the arguments we just talked about. So what would happen if the spouse that's filing for divorce transfers the title to somebody else? If it's your homestead, your spouse is required to sign a waiver of homestead, or waiver of your homestead rights. It's a requirement. So if you find out later, once the divorce is filed, that this property was transferred, I would make a good faith argument stating that, well, they intentionally did this so that they would not have to be responsible, or they would, the other party that's not on the title would not be able to claim any interest in the home. And that does not look good in front of the judge. It looks almost like, I'm not saying it's fraud, but it's definitely something that is on the border of being deceitful. And then there's questions like, what, that deed, is it even valid? Because if you don't have, if it's a homestead property and your spouse didn't join in on the signing, then that can create a lot of issues for a lot of people. So you want to make sure that all of your ducks are in a row. If you want to claim something as being your homestead, you do have the intention of giving your spouse, even if they're not on the title, some sort of right. You are getting a tax benefit from it, and you are required to follow the law. So, and ignorance of the law is not an excuse. You can't say, I didn't know I was the only one on the title. If it's your homestead, then you have some sort of, you should at least talk to your accountant or an attorney to make sure that what you're doing is not, number one, it's consistent and it goes in accordance to the laws of Florida or wherever you are, and number two, that it doesn't create some sort of doubt or some sort of bad connotation or showing that someone is acting in bad faith. Because at the end of the day, when it comes to equitable distribution, if you could show that one of the parties was acting in bad faith or trying to dissipate assets to prevent the other party from getting any, then you could claim more in equitable distribution. That's a conversation for another day, but I'll be sure to include all of these links below. And of course, if you have any questions or really anything you want to learn about in Florida law, specifically family, that's my jam. But anything you want to know in general, please reach out to us, contact us, send us emails, send us messages. We're here to help you, so let us know. Have a great day.